Hey guys, welcome back. So in a most recent video, I sat down with Jason Hunter with Sage Law Partners to talk about trust, living trust, revocable trust. Trusts are part of a bigger picture estate plan. And so today I wanted to talk about the other components and aspects of what an estate plan includes besides the trust. So Jason, what else is involved in putting together a good, complete estate plan?
Yeah, we actually generally include 5 legal documents in a complete estate plan, and the trust is a foundational piece of that. But the 5 documents we usually include are a last will and testament, the trust itself, a property power of attorney, an advanced healthcare directive, and a HIPAA waiver.
So the trust is that main thing that we've already talked about, and I'll kind of reference you guys back to the video on that to get more details on the trust. The next one you mentioned was the last will and testament. What's the purpose of that pour-over will?
You bet. For clients that choose to have a trust-based plan, the idea is to move assets into the trust and to hold them in the trust. Unfortunately, life happens. Maybe you refinance a property or do a business transaction, and an asset ends up outside of the trust. And so what we have a will for is to come in and pick up those assets and move them into the trust. We call it a pour-over will because all it does is pick up assets and pour them over to the trust.
And at the end of the day, I mean, the trust, as we talked about in our other video, trust is that document that provides clarity around what happens with all the assets at the time of death. And so essentially that pour-over will says, look, to have that trust be effective, we want everything to get into the trust. And so if for some reason you've forgotten something or you formed something new or bought something new since you established your trust, it essentially puts it all into the trust upon death. Is that more or less kind of the concept there?
That's it.
Okay. Tell us a little bit about the power of attorney. Taking their power, their own ability to make decisions, and they invest it into somebody else. There's a level of anxiety, I think, that comes with that. Help us kind of get our heads around the anxiety of giving someone that power, and what does that look like in these documents?
Yeah, we work hard to accumulate assets, and we certainly don't want them lost to any rogue actors. A power of attorney is where you delegate to someone a power to make decisions over your property matters, in this case. A power of attorney can come in 2 flavors. It may be an immediate power, that is, when I sign it, it grants the person named as the agent the immediate power to go act on my behalf. Or it may be a springing power, where it springs into effect at some later date. That later date is usually a date of incapacity, which is determined perhaps by a declaration by a few physicians that the person that made the power of attorney is unable to act, or it could be triggered by a court declaration as well. We want to try to keep the courts out of it, so we always try to set up a private determination of incapacity in the power of attorney where we do a springing power.
And if you have established a power of attorney, do you have opportunities at some later time to retract that?
You bet. All of these foundational documents, those 5 foundational documents that I named, they are completely amendable, revocable, and can be changed. You can change the people involved, you can change the terms of the document in the entirety.
Okay. You mentioned 2 healthcare documents as well, Jason. Let's kind of touch on those. You mentioned the HIPAA waiver and also this Utah Advanced Healthcare Directive. Give us a sense of what's the purpose and why does that have a place in the estate plan?
You bet. Many people focus just on the property issues of estate planning, and that is a big deal. We want to make sure we have that taken care of. But I find these 2 simple healthcare documents are exceedingly important for families to have in place. The Utah Advanced Healthcare Directive is a combined medical power of attorney, that is, you've appointed someone else to make medical decisions for you, and living will. And what that means is you get to manifest your wishes regarding your end-of-life desires. So after your medical providers have done everything they can for you, it says, hey, basically this is how I want to die. And that document has 4 options for that process. You can choose to just let your agent decide on what happens, what treatment you do or don't receive. You may decide to have your life prolonged by artificial means or otherwise, or you may decide you don't want your life artificially prolonged and you want to die a natural death. And occasionally all of those decisions are too much and we have somebody decide they just don't want to make a decision, and that is the 4th option. That's the Advanced Healthcare Directive. The other document that you mentioned, the HIPAA waiver, is a document to permit kind of your team, your family, to access your medical records. Many folks are surprised to learn that spouses don't just automatically have rights as to their spouse in terms of property and medical decisions, and certainly children or other actors don't. So you need to designate who can access your medical records so that they can help you deal with asset transitions and healthcare issues.
If people are going to get ready to make a phone call to you to start getting this set up, what should they be thinking about in preparation for that call so that way it's a productive conversation for everyone?
Yeah, you bet. We obviously need to know all of the actors that will be involved in. So usually that is both spouses. We want both spouses there if for married clients. And we need to know names and usually birth dates of children or beneficiaries, heirs if there aren't children, and some basic contact information and just general information about the assets. Many people actually, Brian, are surprised to learn that I don't need detailed financial statements to put together an estate plan. We can talk about the general nature of assets and then figure out what other details we need in the consultation.
As I've said before, I feel like probably half of my client base doesn't have an estate plan, doesn't have the trust set up. I would really invite each of you to reach out to Jason Hunter today to talk through your specific plan and what that might look like for you guys, because given the costs and given the complexity of all of our lives, this is a cost well spent to be able to put together a good plan, a formal plan. And I would also invite you as well that if you've set up a plan a long time ago, 3 to 5 years, you ought to be revisiting your living will, your trust and your estate plan. So I invite you to do that as well.